Hi everybody and welcome to the latest Lawshare Q&A. Thanks very much indeed for joining us, and thanks very much for joining me. So I'm delighted to be joined by expert costs lawyer and director at Kain Knight, Nick McDonnell. Nick, thanks very much for joining me.
Thank you for having me, Peter. Thank you.
Well, this morning we're going to be talking about the hottest topic in town, the Belsner Appeal. So over the last decade or so, Nick has been acting for law firms, assisting and defending challenges to their legal fees from former clients. And more recently, you've been the cost lawyer acting for Kain Legal Services Limited on a much followed and highly anticipated appeal of Kain Legal versus Belsner. It's probably not an understatement, I don't think, to say that this is likely to be the most significant cost case for the last decade. The Court of Appeal finally ruled in this particular case last Thursday, handing down a 23-page judgment. We've now had time to digest that, and we thought it'd be no better time than to sit down with the man at the heart of it, Nick, and to get a bit of an insight into the result and what that means for the future. So just before we get into all of that, Nick, might you be very kind as to quickly bring us up to speed as to how we got there in the first place?
Yes, of course. So, well, I think we can really almost sort of look back 10 years when LASPO was introduced, the Legal Aid Sentencing and Punishment of Offenders Act. And what came with that piece of significant legislation was the abolition, to the large part, for the recoverability of success fees between the parties in litigation. Also, roughly at that time, in the summer of 2013, there were much wider fixed cost regimes implemented. So I think what firms were grappling with at that time was a revenue stream that meant that they were able to recover their fees on a conventional basis, an hourly rate time spent basis, and in addition they were able to have a success fee that was recoverable between the parties. And then quite quickly, within a short space of time, these firms were only being able to recover fixed costs and no success fees between the parties. But lots of firms still needed to recover a success fee, because the whole idea of a success fee is that firms get paid on the winning cases and that funds the cases that lose. So they still needed to do that, but that then transitioned to be an item of cost that became payable by their own client as opposed to an opponent. So where we ended up really was a sort of a fundamental change in how firms were having to conduct their cases, so that much of the legal fees, or certainly a much larger part of the legal fees, became payable by their own client. A complete change of behaviour from historically, where clients tended not to have to pay anything towards their legal fees. Almost the entirety of their fees were paid by opponents. But with a switch like that, and when clients are being asked to pay for their own legal fees, they're obviously going to be more interested and concerned in what those charges are. So quite quickly, over the course of the next few years following 2013, we started to see challenges coming through with regards to those fees that were being deducted from damages. And that really is how we got to this point where we are at the minute, because the wheels of justice do turn very slowly. These points tend to develop over a period of time, and it eventually does take a little bit of a while to get to the Court of Appeal. But here we are nearly 10 years later, and we've got an examination of some of the key issues that are at the heart of solicitors deducting fees from damages.
Excellent, thanks ever so much, Nick. So the lawyers have won out. The Master of the Roll, Sir Geoffrey Ross, handed down a judgment which found in favour of the solicitors on every single legal point, as I understand, and even went as far as to criticise Belsner's legal representatives, checkmylegalfees.com, actually calling into question their business model. So happy days, one might think, but that doesn't tell the full story, or does it?
Well, I mean, the appeal was allowed. It was a profound success You're absolutely right that the solicitors won on every single legal point. But the Master of the Rolls isn't backwards in coming forwards in terms of commenting upon business practices and how perhaps firms on either side of the fence should perhaps deal with things differently moving forward. So certainly Check My Legal Fees, who acted for Kain Legal Services' former clients, their business practices were criticised. Traditionally, legal fees, when challenged by a client, is done through the Solicitors Act. And those are detailed assessment proceedings that are brought in the High Court, which, if the fees are substantial, you know, in the thousands of pounds or tens of thousands of pounds or hundreds of thousands of pounds, then it's an area that is particularly suited for those types of disputes. Where I think the court had difficulty with reconciling certain things is the fact that the dispute here was a mere few £100s, and yet firms were spending thousands of pounds in having to bring or defend these challenges. And you're absolutely right to say that it isn't the end of the story, because obviously not only have we got the costs of the appeal now that we're dealing with, but there's also, you know, what happens next? What are the ramifications of this? The court has criticised clients for bringing challenges for low value or trivial amounts in terms of bills, and using the detailed assessment procedure in the High Court under the Solicitors Act, and has suggested that perhaps a more appropriate route is using the Ombudsman. So their business model has been criticised. It's going to be interesting to see what happens over the next few weeks and months as to how they adopt the advice given by the Court of Appeal and change tact perhaps as to how these challenges are dealt with. So I suppose we will see, but there's still a lot to be said and done in this area.
Okay, because the ruling also stated that the solicitors may not have complied with the SRA Code of Conduct. Quite a bold statement. Can you expand on that for us?
Of course. So that's absolutely right. I mean, the Code of Conduct has a requirement, amongst many other things, that solicitors provide the best legal advice.
Sure.
Now, best is quite a subjective term, and is based very much on the facts of any given situation. And in fact, I think it's important to say, first of all, that the Master of the Rolls was quite clear that the majority of the key information that a client would need to hear in order to make an informed decision about whether or not to instruct a firm of solicitors and agree a funding arrangement was actually given by the firm. The vital piece of information, vital, the word being that the Master of the Rolls used, that he said was omitted, was advising the client as to the likely recoverable fixed costs. Now, I think fixed costs can vary because there's various different trigger points as to what fixed costs apply. So you can have some sympathy for the solicitors in not advising them about what fixed cost may be applicable, because cases can settle at different stages and different fixed costs can apply. And the firm felt that they had done enough. I think with the benefit of hindsight, the court believed that actually, you know, it isn't too difficult to provide the client with the menu of fixed costs that could be recovered. Whether clients will actually read such a thing is a different matter altogether.
Sure.
But certainly the box could be ticked moving forward to provide the information as to which fixed cost will apply in certain circumstances. So that being a vital piece of information, as the Master of the Rolls said, that wasn't given, it then followed, in his view, that the best advice hadn't been given. However, it was very much appreciated that the context of this case was that it began only a few years after the introduction of LASPO. So the legal industry was still finding their feet in terms of what information needs to be provided and what is the best practice. And these things inevitably occur over a period of time.
Yeah.
So even though the Master of the Rolls was critical and did actually say that there had been a breach of the code, the reality is that notwithstanding that, he still found that the fees that were charged were still fair and reasonable. So on the spectrum of non-compliance, I think it's very low on the severity element of this. But I think what will come from this is that with the court having given this sort of foreshadowed this particular issue, the expectation will be that firms moving forward must deal with things better, to include, where fixed costs are applicable, what the menu of fixed costs that will apply in the various circumstances.
Excellent. Well, that leads on to our next question perfectly. The Master of the Rolls also found that the current legal framework and the practices of some solicitors is, and I quote, unsatisfactory. What exactly was deemed unsatisfactory?
Well, I think one of the main things that the Master of the Rolls had difficulty and felt uncomfortable with was this idea that solicitors will charge their fees on an hourly rate, time spent basis, give an estimate of what their fees may be towards the end of the case, at the point they think the case may settle, and then at the end of the case apply a self-imposed cap on those fees. So at the start of the relationship, it's unknown what the fees are likely to be, because who knows which way the case is going to go.
Of course.
And then at the end of the case, applying a cap, which only provides the client with a level of certainty and comfort at the back end of the process. What he found unsatisfactory was that the client should, and didn't in this case, have a much clearer idea of what their overall exposure to costs would be. Having said that, as I mentioned earlier, this was quite early on in the chronology from the change in legislation, and practices have changed significantly over time, so that even though the kinds of certainty that the legislation provides for, which is success fees are capped at 25% of the damages, the uncertainty is in respect of profit costs.
Yeah.
There's no statutory regulation that caps those charges, but the way the practice has developed is that solicitors will now quite often, and in most cases, give a client an overall cap. So quite often you will have firms saying, we don't know how much this is going to cost, our hourly rates are X, we think we may spend Y amount of time, but what we can say is that no matter how much it costs, our total fees over and above what we recover from the other side will never be more than X% of your damages. Yeah. So the practice now seems to be that firms are providing this overall cap as a security and comfort for clients, so that they know that they're always going to come out with 70% of their damages, or 75%, or something like that. Yeah. And that's really where the practices have developed to provide greater certainty these days.
Thanks, Nick. Voss said the distinction between contentious and non-contentious costs was, and I quote, outdated and illogical, and an urgent need of legislative attention. What might that legislative attention look like?
Well, I think the first thing is that the definitions of contentious and non-contentious business, which start with the Solicitors Act and have been defined in common law, are definitions that have been established for about 60 years. So everybody's been working to the same rule book as to what contentious and non-contentious business means. But in the modern day legal landscape, I think there's some merit in what the Master of the Rolls says, because what the Solicitors Act does do is it sets out two different regimes where costs are to be assessed, depending on whether business is contentious business or non-contentious business. The regime, as it's been established in Belsner, is that non-contentious business, those costs need to be fair and reasonable, whereas on contentious business, they only need to be reasonable. There isn't an element of fairness as expressed within the criteria that the court needs to apply. But there is no logical reason why the division, the current division for the difference between contentious business and non-contentious business is whether proceedings are issued. The simple fact of proceedings being issued immediately changes the way that costs are to be assessed, not just moving forward from that point, but retrospectively. And I think the unsatisfactory element that he was referring to is that clients need to be better informed and have a better understanding about what they're able to tap into in terms of challenging fees. And it's very difficult to explain to a client that, well, the test for fees before proceedings are issued is X, but actually the test changes when it's Y, X and Y being the issue of proceedings and not. And because the way the legal landscape is developing, there's going to be greater, there already is huge emphasis on using pre-action protocols, but there's going to be even greater emphasis on using pre-action protocols moving forward. So it doesn't seem sensible, he said, to have two different regimes depending on whether costs sit in pre-action protocols or whether proceedings are issued. So in terms of what the legislative changes might look like, I think it will create greater consistency so that the tests are the same whether or not proceedings are issued, so that the client has the same understanding as to how they can go about challenging fees and what the expectation is in terms of the reasonableness and or fairness of those fees.
Okay. Now, we've touched on this already, but am I right in thinking the amount in question was rather modest, I think around the £300 mark, unlike the legal costs involved in this appeal? So one assumes the claimant won't be paying for this. Does this spell the end of checkmylegalfees.com and similar models to them, do you think?
Well, just in terms of that, only time will tell. We're quite early on, within a week from judgment being handed down, and no doubt they are taking stock. Their business model has been heavily criticised, and a lot of the comments are to discourage these types of practices. So no doubt they will be thinking carefully about how they are to conduct their business moving forward. You're absolutely right that the sums in issue were very small, relatively speaking. It was just shy of £300 in the end. It was the battleground, if you like, between the parties. But substantial sums have been spent. Now, as a starting point, yes, Ms. Belsner will be primarily responsible for these fees. However, as we understand it, part of Check My Legal Fees' business model is that they provide their clients with an indemnity. So they pick up the tab, essentially.
It's underwritten
for their clients. Yeah, that's absolutely right, although, interestingly, the regulation for insurers who operate in a similar kind of area is very, very fierce and very, very high. There's a lot of regulation if insurers are to provide indemnities and sell policies of insurance. The regulation associated with firms of solicitors providing indemnities is virtually non-existent. So it's not yet known whether Check My Legal Fees will have sufficient assets or sufficient cash in order to not only pay the costs associated with Belsner, but there's well over 1,000 cases that are stayed pending the outcome of this case. And if they are providing similar indemnities to all their clients on all of those cases, and the effect of Belsner is that those cases are likely to lose moving forward, the cumulative liabilities of that indemnity could be well over £1 million and possibly up towards £2 million. So Yes, in the first instance, Ms Belsner will be responsible, but as I understand it, their model is that they will indemnify it, and time will tell whether they can meet those indemnities.
So it's far-reaching, isn't it? Really, it's despite us talking about, like say, a modest amount at first, the implications of this are huge for everyone in the industry. Well, Nick, thanks ever so much. Absolutely fascinating. Very well done on the appeal.
Thank you very much.
I know there's still a lot to follow, and you've been very busy in the time, so I'm very grateful for you making the time for myself, the Lawshare team, and more importantly, obviously, the members of Lawshare. If you'd like to reach out to Nick and the specialists at Kain Knight, then of course, by all means, do that directly. Or if you'd like to be put in touch, you need their contact details following this particular talk, then you know the email address. It's lawshare@jmw.co.uk. The team and I more than happy to have a chat, put you in touch with Nick and the specialists at Kain Knight. So it just falls to me again to say thanks ever so much for your time, Nick. It's been an absolute pleasure, and thank you for joining us.
Thank you.